Good afternoon, everyone. I'm grateful for the opportunity to talk to you today about fitness to practice and the impact on your professional indemnity insurance. Often we're seen to be just a placement of insurance, but quite often we will provide risk management advice to you. In some ways, we are sent in to instill a little bit of fear in clients. That's not always a bad thing. So what I'll be covering today really is what your PI insurance obligations are and why it matters, what are the obligations owed to your clients, and of course the medium-term future of your business, succession planning and running off liability. Just briefly, as a quick reminder, what is professional indemnity insurance? Well, it's essentially the payment of damages and legal costs in the event of a claim made against you. As you may know, those claims can be in respect of any negligent acts, errors or omissions, or breach of contract, any allegations of the same. The key point here is that professional indemnity insurance is claims made cover. So it's the policy in force at the time a claim is notified, not when the services were provided or the alleged negligence occurred, which responds. I'll touch upon the importance of this later. Of course, it's a requirement under 2.1 of the Code of Conduct to ensure that appropriate professional indemnity insurance is carried and, of course, maintained. So what are your professional indemnity insurance obligations and why does this matter? The crux of what I'm going to be talking about really is disclosure. This is a huge area in terms of the academic aspect of insurance law. I'm hoping I can take a practical perspective on this throughout. So what are material facts and what is fair presentation of the risk? Well, it's a fundamental general principle that you as the insured have an obligation of utmost good faith to your insurers. Essentially, what this means is that whilst you can be quite commercial and tactical in the information and your dealings with your insurers, you do have to deal with them on an open book basis, something that the law doesn't actually require of you in the context of any other commercial contracts. In practice, this means that when you're forming the contract, and that would be completing a proposal form, for example, you have a duty to answer all questions on that in a comprehensive and honest way. It also means that you have a duty to disclose all material facts. Material facts are essentially any issues that will be relevant to an underwriter in considering your risk. Most material facts are drawn out by the specific questions that appear on your proposal form. And I've got a bit of an example here on how the final declaration on your proposal form might look like. Essentially, most material facts are drawn out by specific questions. They might be closed questions, yes or no confirmation, some tick boxes, but then you will have an obligation usually at the end of your proposal form to set out any other matters that you deem relevant to your professional indemnity insurance proposal. Inevitably, no proposal form is going to capture enough information or be comprehensive enough to really anticipate everything that an underwriter will want to know and, of course, deem relevant. If there's something particularly niche about your practice or quite unusual, for example, relevant to today, if there's nothing particularly positive, that's something that you would need to draw out in that additional questionnaire. But of course, it can be difficult to know how to distinguish a material fact if you're not an underwriter, and we understand that. Hopefully, this is where an experienced specialist broker can actually come in handy. It's our job to understand how underwriters think, and because we're dealing with them all of the time, we know what sort of line of inquiry will be undertaken. We can preempt the questions that will be asked far in advance, and we can keep abreast of any series of questions and lines of inquiry which are new or quite current. Most proposal forms ask questions about directors or principals in consultancy firms. Have they ever been declared bankrupt or convicted of an offence? Or have they ever been directors in firms that have been subject to insolvency proceedings? I'm not quite sure that they ask all questions such as whether you are involved at present in disciplinary proceedings. The series of proposal forms that I work with don't have that set out, although some may do within the market. In my view, any such proceedings probably would amount to material facts, particularly if a complaint against you is upheld by the Professional Conduct Committee. although much will inevitably depend on the precise detail in each case. It will depend on the time and on the stage with which an allegation or investigation may be at, and so on. Often they lend themselves hand in hand. If there is an investigation, there may be other circumstances which may give rise to a claim. Certainly, if the institution of structural engineers have decided that you are unfit to practice, your insurers would regard this as a material fact and would expect you to declare that on your proposal form. That will probably then prompt further questions from insurers, but frankly, it will probably only result, and this is what we're most concerned with today, in insurers declining to renew your policy or offering to renew it with significant alterations to the cover. For example, they may only cover the work undertaken by the relevant individual. It might be that they cap that to a certain date. It might be that they exclude cover for work done by that individual or insist on a higher excess applicable to your insurance, or they may reduce your policy limit, because in essence what they see is that there's a higher risk involved. Now, material facts should normally be shared with insurers promptly if they change the nature of the risk. However, and quite significantly, insurers can usually only take the steps that I have briefly outlined at renewal process. They don't generally have the right to amend terms of your policy mid-term. They wouldn't then actually require additional premium payable, for example. They'd like that, of course. They'd like the ability to protect themselves and re-rate and reprice your risk. But what I would make you aware of is that a no claims declaration form, should you wish to make any changes to your policy mid-term, this can be because you've changed your limit of indemnity, you might be adding an additional insured practice to the risk, all those touch points within the policy period. This then acts as a refresher to bridge the gap between what you've disclosed to your insurers in your proposal form and the present date. Now, essentially what it does, and I'm not sure if you can see it really clearly, there's a bit of a footnote as well to it, is that you have to ensure that you're signing that from the date of a proposal form there's been no material change, that you're not concealing any material fact, and of course that you've made full inquiries, there's no knowledge or circumstances which might give rise to a claim. Essentially, a further obligation for you to take stock, look back, and if you have anything further that you need to provide, the small footnote at the bottom is that you will present that to your insurers. The position is slightly different if you were to reach renewal stage and you should have declared something mid-term, and vice versa. If you're in the middle of your policy and you didn't disclose something at your proposal form at renewal. I won't go into the detailed legal ins and outs of this today because we don't need to. Essentially, it's when there's non-disclosure. But suffice to say, in general terms, if you put yourself in that position by failing to disclose those facts, you do run the risk of uninsured losses, and ultimately, insurers might, in some instances, be entitled to cancel your policy. Simply because there's an absence of insurance does not necessarily mean that a claim will go away. A claimant may actually see that the lack of professional indemnity insurance means that essentially there's no funds to back that claim, although what might happen is they may back away, but you've ultimately had to incur the costs of defending that claim yourself. So moving on to obligations owed to your clients. Should you disclose this to your clients? Well, in essence, yes, of course. It's a case of demonstrating how well you manage your clients and projects. It's important for your renewal. Quite often, as an example, we regularly request that risk management questionnaires are obtained as part of renewal process. That can range from questions as to how you deal with your clients, how you contract with your clients, and so on. It may be worthwhile, of course, in engaging with your client that you talk about any concerns that you're having, potentially discussions with your brokers, should there be any potential for problems at renewal or the risk of no insurance terms being proposed. Of course, remember in 2.1 of the Code of Conduct, you should inform your client if PI is no longer carried. In practice, what you will find is that your clients will have all your information on file in the form of disclosure documents and evidence of cover certificates. I'm sure that you'd be prompted at that point for your new evidence of cover documents on or very near to your renewal date. Portals such as Builders Profile will also no doubt be forthcoming, and they normally require broker validation. So aside from all of those, what are the contractual obligations that you owe towards your client? These really lie in the letters of appointments and so on that you will sign up to, bespoke documents and so on. You're usually required to maintain professional indemnity insurance for a specific period, and that's usually 6 or 12 years. And quite often you'll find that you're expressly obliged to notify your client of any changes or absence of professional indemnity insurance. This is very common. There's normally an obligation that you'll maintain professional indemnity insurance for as long as that is commercially reasonable and available. However, there's normally a further footnote there which refers to your own acts, your own omissions, your own errors, and your own claim record being deemed to be within commercially reasonable rates. So essentially, you wouldn't be able to argue the point with your client that your professional indemnity insurance is no longer available at commercially reasonable rates simply because it's been subject to higher or certain rating action because of the issues here. An employee, for example, deemed to be unfit to practice. Finally, medium-term risks. So medium-term future of your business, succession planning and running off liability and risk. Notwithstanding that insurers can't take immediate action, disclosure of material facts promptly is still a very good idea. This is because it's good management practice for yourselves. It de-risks the situation for you, and it means that your broker, rather than you, has to remember to include the material facts in the renewal negotiations with insurers. Please make it the onus on your broker to actually propose that information and manage it accordingly. It'll allow you the opportunity to understand what to expect at renewal, which in turn will have implications for the way in which you run your business. If your broker, for example, advises you halfway through the policy year that any work done by employee X won't be covered following expiry of your policy, then that will no doubt form and influence the way you think about and manage that individual. It'll give you a bit of time to think about any related client management issues. If the advice again from your broker is that insurers will simply not provide you with renewal, then you have time to shop around for the rest of the market and find an alternative provider. If it seems unlikely that anyone will insure your past or your future work, then you need to know that as soon as possible so that you can take advice on whether you want to continue trading at all and also what options you have available for protecting any assets. This will, of course, include personal assets if you're a sole trader or a partner. Now, the more positive news, coming back to that point of claims made basis, the absence of any cover in future periods does not mean that you have no cover for claims notified to insurers prior to that point. So any claims arising out of matters notified in previous policy periods, rest assured, will still be paid, as will any claims notified in the current period. If one of your employees has been declared unfit to practice, you might use the time between learning of that and the expiry date of your current policy to review the files, for example, check your record keeping, and of course consider if you found any evidence whatsoever of a circumstance which might give rise to a claim. For example, you review a file and you discover there are any mistakes and omissions from that, and it's been issued to a client. It is good practice in claims notification that if in doubt, contact your brokers to advise further. To explain the process a little bit further, your broker should then determine if it is a notifiable circumstance, which might give rise to a claim, or in many instances, it's purely precautionary and will continue to be monitored. Rest assured, quite often it is a purely precautionary notification, and these normally do not amount to a claim. What can you do in the absence of cover in future periods? You'd be inclined to engage with your broker at the earliest opportunity to discuss any concerns. Of course, it's an opportunity to keep an open dialogue, and it doesn't have to just be at renewal. It'll allow you as well to have some autonomy over how your PI renewal will be approached and the strategy which will be deployed. The earlier your broker can understand the potential hurdles which might be faced, the earlier they can formulate the presentation to existing insurers and, of course, assess if you have to look at any other alternative markets. If the renewal process has been difficult, what steps can you take for this year and subsequent years? It's normally a case of a real tripartite approach between yourself, your insurers and your brokers. There's likely to be plenty of questions and answers to hopefully identify these concerns. It would hopefully then allow you time to go away, obtain the necessary evidence and information, and present us with what we call chapter and verse and lessons learned. The insurer can then act accordingly, potentially propose terms, and if so, explain what restrictions will be in place. This would normally be by way of endorsement. This will be reviewed at renewal, and hopefully, as time progresses, the position may improve and the restriction may be removed. But what if that restriction doesn't and the position is more serious? It's worth noting that if you're unable to trade, there are a couple of options. Run-off cover, if for those of you who are not aware, is essentially a way of running off your past liability. It would be only for previous projects, it would not be to cover you for any future work. It's questions to think about when you're no longer trading. Have a think about previous contracts and their requirements to maintain professional indemnity insurance. Running off liability usually means that the risk reduces in the eyes of the underwriter, but not always. A run-off policy would be annually renewable in the same way as a professional indemnity insurance policy. You'd have to consider the cost of run-off as well, as usually that is a recommendation to carry that for 6 years. Of course, the cost, if there is a diminishing risk, would reduce year on year. In some cases, some clients, where there is a possibility that there are ongoing obligations to their clients, there is a consideration that they would sell both the goodwill of the business and, of course, sell the liability of the business. It's always worthwhile to talk to your brokers as to what run-off options are available. The key messages really to take from today is if you're querying whether you should disclose a piece of information or a material fact, the answer probably is yes. You should consider your renewal exercise as a chance to review processes and procedures and seek guidance, but you do not always need to wait for renewal. As mentioned earlier, you might have touch points in the policy period where you need to contact your insurers, and of course, there is always an opportunity for a mid-term adjustment and no claims declaration form, more specifically, to be signed, and of course, the obligation to disclose is once again reignited. It's important to choose the right advisors to formulate a succession plan for your business, as professional indemnity insurance underpins your business and is the second largest cost of, well, the second largest outgoing to your business, second from staff pay. It really is essential to see it as part of an ongoing concern. I do believe that we've got an open discussion, an opportunity to cover any questions, but in the absence of any business cards, my details are above if you've got any specific questions that I've not covered today. Thank you very much.